The judgment is wrong, not the chart. What the part people will show? When the matter is being argued,
Yes.
they would not know what judgment will be
That
filed.
is your argument. Show us from the affidavit that this point was taken.
The point, nobody has.
You have no locus to say that. This is on the basis of the records of writ petition. You are the appellants before us now.
Yes, yes.
Have you filed any pleadings? You had no scope to use any pleadings in that writ petition.
Correct.
So you show us that this point was taken by the respondents in their affidavit in opposition.
Now, what point could be taken? What point? What is the point?
Mr. Mitra, kindly concise yourself to the actual challenge.
My lord, kindly.
You are taking us on the basis of this, that there was no pleading, nothing was said, advocates were silent, court on itself arrived at this corner. This is your argument. Yes.
Court arrived at this as his final judgment from a report submitted to him by the board as per his direction. And from that report, court found that 14 was the lowest mark for bedroom SC, let us submit. Now, in the judgment, what the court will say, nobody would know.
I think we are not clear to you. We have asked you that this argument which you are advancing before us, was there any glimpse of such pleading in the records before the writ court? If this is taken
we are not parties. We are not parties.
Not of you. We are not saying you. We are saying about the board and the board in the writ petition. Board has never said this. That what, my lord, you are referring, this is a wrong statement you are recording.
One mistake. Can you permit me?
All right, Mr. Mitra,
you proceed. Lordship making with respect one mistake. The mistake of the judge is appearing in the judgment. How the board will know that this mistake will be committed by the judgment in the judgment when the argument was going on?
No. Was it not incumbent upon the board to tell to the court the argument which you are advancing?
No.
14
kindly allow me, kindly can listen to it. This, that the board, that court will file a judgment as a ground saying that the total lowest mark was 14 points such and such. And the writ petitioner has scored more than or near that, and how would the board know? Was this point indicated? Judgment was given, dictated in court, and then argument started. Argument starts after judgment. How would the board know? Anybody would know that the judge will make it a ground when it is not in the pleading? Please consider from that angle. I am asserting the judgment.
50, on the basis 50 occasions the writ petition was heard.
Writ petition was heard.
And this exception was filed on 11 January.
In the writ petition, is it anywhere stated that 14.191 was the overall lowest mark? Not stated anywhere.
That has come on record on 11th of January. That is from the report. Serial number 19. Yes, Mr. Mitra.
May I just humbly summarize what I am saying? In the judgment, court has given a new ground for cancellation of appointment. The new ground is that district-wise, lowest pass mark was 14.191. And although there were candidates who have scored more, they were ignored. This point, if not taken in writ petition, one would not know how to deal with that. It is nowhere on record that judge, honorable judge, in course of hearing, disclosed to the parties, appearing parties, that this point is troubling me, as normally fair judges do. This point is troubling me. I find that district-wise lowest pass mark was 14, and so many writ petitioners got more than that. If the question was put, the learned judge, learned counsel, appellate board would have the occasion to say, would have the opportunity to say, the lordship, we are making a mistake. 14 is not the benchmark for the entire candidates. It is only the benchmark for one district Birbhum scheduled caste. And kindly see, has any of the writ petitioners got more than that? Any of the petitioner belonging to Birbhum SC has got more than that.
Only one person was there. Only one person was there.
Only one person did petitioners. So, Miller, he had below this. No. Yeah. Now, let us take one by one. Therefore, this reasoning given by the learned judge in the judgment is factually incorrect. And learned judge, if I put most humbly,